Okay, good morning, everybody. Thank you so much for attending on this very cold morning. It's probably easier to stay indoors and watch videos like this one instead of going out. So welcome to this POPIA, Protection of Personal Information Act, action steps for state agents. The first thing is, I don't know if I need to apologize about our green and evil or furtive looking cover page. Our media consultant said that it doesn't look good, it was negative. I said, well, look, you know what? In our new global digital world, we are now surrounded by fraudsters, hackers, devious people, thieving people, and this is the reality that we are now facing. And I think it's a good thing that now we have to have our personal information managed and controlled, and similarly that we must control and manage the information of our customers and clients. So that's why I've got this evil, furtive looking page. It is to impress upon us why we need to protect information. This is driving the message home. So moving on, we'll welcome you here. This is Denoon, Sampson and Lawvu attorneys. As you can see, there's our photograph. Our offices are just to the left by that stop sign there, and then our billboards on the right. We've been on the go for 30 years, more than 30 years actually. So today this talk is going to focus on what an individual needs to know to carry on his day-to-day business. Today we are not focusing on what companies must do, because this legislation is huge and it's full of tiny little bits of detail, and so it's too long to deal with both sides of it. So today we're only talking about individuals and what an individual needs to do to comply with on FICA. I'm not FICA. You can see it's FICA, BEE, and now POPI. So really, we're getting confused with all of this rigorous compliance legislation. So for the sake of brevity, this presentation deals only with the key aspects of legislation. And obviously, if you need, this is a disclaimer, this is not legal advice, this is a general overview. And so if one needs legal advice, you need to take it from your specialist attorney. So we must all know that the legislation will take effect now in 3 weeks' time, the 1st of July. So what are we going to discuss this morning? I'm going to give you 2 examples of why we want our personal information protected. What is this POPI all about? The definition of what is personal information, and how the law tells us we must deal with this personal information. The fact that your company must register an information officer, and we're going to talk about consent to use information, which is a keystone of the Act. We're going to be talking about direct marketing, lead generation, and I've got some clauses here that you may wish to put into your agreements, managing records of POPI and keeping track of our leads. So the first example is an unlawful SIM card swap. Now, this is actually what happened to myself on my own personal cell phone, and how it caused this law firm to lose a lot of money out of its business account. So a leading cell phone company allowed somebody to steal my SIM card by means of a fraudulent SIM card swap. Now, in those days, maybe it was 5 years ago, a SIM card contained one's personal information, passwords, email addresses, and unique stuff that was fundamental if you were going to do a transaction. So what happened when I was at the farm on the long weekend, out of range? I didn't use my cell phone because I didn't need to, but when we came back on Monday morning, our bookkeeper discovered that money was coming out of our business account, just unlawfully, just disappearing. So we phoned the bank, and they, instead of freezing the account, instead of reversing the money, they just said the fraud division must handle it. So the fraud division did nothing. So the point is, the fraudster got control of my SIM card unlawfully. That's my personal information. And they used it to do EFTs out of this firm's business account. We lost a lot of money. and the cell phone company ignored our demands. I wrote letters of demand basically on the forerunner of this legislation, and you'll get to know what it's all about. However, the bank was jointly negligent, so they compensated us, and this matter actually went to the magistrates court and so forth. Now, there's an example of an unlawful SIM card swap. Look at this. This is a crime syndicate discovered with all these unlawful SIM cards. Look at those cell phones. So this is really what we're facing. Organized syndicates that are stealing our information. And this is what caused financial loss to Denoon and a lot of other people. So just to continue with the unlawful SIM card swap, if this POPIA legislation had been in place, then under threat of a 10 million rand fine and 10 years of jail imprisonment, I'm sure this leading cell phone company would have, I hope, nowadays protect my personal information. So this is what would happen now. This is what the law compels a SIM card cell phone company to do if someone wants to take control of my information. So the Act would do now, because we were told that the only information I could get out of this was that it was a franchise branch or a satellite branch of the leading cell phone company that had done an unlawful SIM card swap. But that's all I could get. So nowadays, under the new legislation, which is going to take effect on the 1st of July, whoever wants to take control of my information will have to do the following. Now, they would have to make a direct request to me by requesting my written consent to its collection of my information. So now if you go and swap your SIM card, you have to sign a whole lot of forms with cell phone companies. And I can see some people know about this. They might call it RICO or something. But now there are forms and procedures that these SIM card companies want to employ. So secondly, the form would have to specify the purpose of it wanting my information, and it would have to tell me the manner in which my information was to be processed, and it would have to give me contact details and the address of whoever's going to use my information. Now, I didn't know which satellite office or where it was, but in the current regime or the future regime, I would have the address and the details of whoever's going to use my SIM card. And of course, all these questions would have deterred a fraudster, I hope, under control and management of the large cell phone company from unlawfully using my information. So that's the first example. The second example relates to not sharing passwords. Now, if we take a note of what is the definition of personal information in terms of our new legislation, it merely says, this is the definition from the section. It relates to an identifiable living person. The word is, it's information that relates to a person. Now, that is so wide and open-ended. You could actually say it is about an identifiable living person. So any information that is about somebody needs to be protected. So sharing a password is like giving someone access to your very private cell phone or diary. In fact, our insurers advise that a very high percentage of fraud and theft come from our own staff, actually. So this is the example of our client. Our client did not take the no sharing of passwords rule seriously. So any staff member could access another's computer through the office computer network, as each computer was not uniquely password protected. So whilst one staff member was on leave, another employee anonymously accessed a computer through the network and diverted 45,000 Rand that was due to be refunded to the company's client. It was established subsequently that the money was paid to her boyfriend. Now, under the new regime, because we have to now have unique passwords for each computer, it would not have been able to happen. So basically, if each employee's computer had its own unique password and private password, it would not be possible, and it is not possible now, to access someone else's information and to engage in transactions. So that is the second example. Okay, let's get into the legislation here. Generally speaking, what is POPI or POPI all about? It is the protection, as I've made very clear, of personal information, giving effect to our constitutional right of privacy. The law prescribes in great detail how POPI should be processed. In fact, this act is huge and it's full of lots of detail, and it's a huge thing to sift out and to go through. But I boiled it down into two unique components. So the Act also limits direct marketing in the case of unsolicited electronic communications. It deals with the rights and duties of users of the information. A user of the information is called a responsible party. And that can be estate agents, brokers, bond originators, conveyancers, pathologists, doctors, dentists, all sorts of people, insurance companies. It's basically anyone who processes the information of another. It gives rights to those people who own the information. They are called data subjects. And that can be buyers and sellers and so forth, patients and insured people and so forth. And it requires each institution to appoint and register an information officer. Now, we're coming on to this word POPI, this acronym. I don't know how to pronounce it, but I hear people saying POPI, but my inclination is to say POPI. So if there are any English professors watching this, I'd love to know from them, how do we pronounce this word? But this is what I think. If you take the word scrapping and you take out the P, you get scrape. If you have the word hopping and you take out the letter P, you get hope. If you have the word sunny boy like they use in America, and you take out the N, you get from sunny, you get Sony. And if you have the word poppy that relates to a flower, you take out the word P and you get Pope. Now, if we have this acronym, POPI, and you take out the word P, what do you get? Popey. So in essence, folks, we're not talking about flowers in the First World War. We are talking about Popey. So this is my view. We're not talking about flowers, we're talking about Popey. Okay, let's move on now. Now, what does the POPI legislation actually include? As I've said, the information is defined as relating to an identifiable and living person. It basically includes everything about the person. For instance, the mental health, the marital status, age, social origin, nationality, religion, and so forth. It also includes biometric information, such as fingerprints, face shape, hand, iris measurement, handwriting, finger and vein patterns. These are measurements of your physique. That is what's included in POPI. This personal information, such as fingerprints and so forth, also has to be protected. It includes the personal opinions and views of a person. So if I have an opinion about a staff member, that staff member should know that I am basically infringing their privacy because it falls within the definition of personal information. And it goes even further. It covers the views and opinions given by a person about another person. So if we're talking about somebody, that information is also protected. So we have defamation where we make slanderous comments, but this is wider. It's even more broad. And it includes confidential information about a person, medical records. I don't know if it covers DNA, paternity suits, because biometric information deals with a measurement. I think it's more physical, I'm not sure. That's something I don't know. But interestingly, there's an exception. And by the way, this legislation has so many exceptions, it's unbelievable. So this is one of them, an exception to what is information or what you can use. The processing of personal information for journalistic, literary, or artistic expression is allowed because it reconciles with the right of freedom of expression. So you can disclose personal information if you're being journalistic, which is quite bizarre to me. So we're not just talking about passwords, bank details, and email addresses. As I've made the point, it's very wide in its definition. And so we have to be aware of this very broad definition of what is personal information. Moving on. So how and why is this information dealt with? The Act prescribes this. It actually sets out in great detail how we must deal with the collection of, the usage, the sharing, the storage, the archiving, and the disposal of information. It also deals with how information is to be shared, both internationally and locally. It deals with what type of information is to be processed and for what purpose. It also makes it very clear that individuals are entitled to be aware of what is being done with the information. So in the case of my SIM card swap, I now am entitled to have been told what they were going to do with it. And it also summarizes, well, it deals with a whole lot of other things, such as the responsible party, that's the user, the law firm, the estate agency, must take appropriate technical and organizational measures to prevent the loss of, damage to, the unauthorized destruction, the use of, and access to personal information. Now we're moving on to the awareness of POPIA. Now you can see all these concepts. I really like this graphic because it shows all these concepts here that are probably in your laptop, but as the graphic shows, it should get into your head. You need to know about these things in your head. And there's a lot of information, but we are dealing with the key points. So this is a great graphic. Section 18 now elaborates on awareness. It says here, a responsible party is obliged to ensure that the data subject, that's the client, is aware of the following. Your client or your customer must be aware of the information that's being collected, and if not from a data subject himself, aware of the source from which it's collected. The customer must be aware of the name and address of whoever's using it, okay? They must be aware of the purpose of its collection, and they must be aware of whether or not the supply of information by the data subject is voluntary or mandatory. They must also be aware of the law authorizing and requiring the collection of information, and also a person whose information is to be protected, they must be aware of the level of protection afforded to that information if it is to be transferred to a third country or international organization. It's quite a lot of things that we've got to arrange as a user to get our customers aware of. That's section 18. Information officer. Now the legislation provides that each entity or company must appoint an information officer. And so we have to register, each company must register its information officer. This must be a senior person. And at the top there in blue, I don't know if you can see it, there is the link that will provide you with the website within which you should register your senior person. The senior person must be charged with setting up an information structure framework that includes the storage, secure storage of leads, and it's about training and on how compliant information in that organization must be done. So on the right-hand side, you can see my registration certificate. I registered with the information regulator. That's a government information regulator. And there's my certificate. Maybe I should stick this on our website so that everyone can, I don't know, relax or get excited. Let's move on to what is generally required from a real estate perspective. In part, this is a sort of a summary. It is that the collection of personal information must be taken directly from the data subject, implying his consent, unless it is derived from a public record or has been deliberately made public by the data subject, or it was obtained for a specific purpose related to your functions as an agent. The person must be informed that you have received such information and how it will be processed, as we just mentioned in Regulation 18. And the client must also be given an opportunity to object to the use of his information at any time. Consent of the owner. Now, this is a founding principle that goes right through the legislation. In terms of clause 9A, it says a person is entitled to have his privacy not infringed. So we got this basic protection that our privacy must not be infringed. So if you're going to use this guy's privacy, you have to get his consent, obviously. And this is what the whole act is about. So as a general principle, when someone's personal information is to be used by another, the use of that information must be obtained. So the use of that information must have obtained the consent of the owner, the data subject. Now the legislation has a continuous thread running through it that a consent in practically all cases must be obtained by the user. So we have to get consent in practically all instances. And it's interesting that the word consent appears more than 35 times in the legislation. So this is the key of it. It's about consent, getting consent of your customer. In terms of section 11(2)(b), it actually says that the above consent may be withdrawn at any time. So you might have got consent, and then if something goes wrong, your customer is entitled to withdraw that consent. So in our new regime, we've got to understand now that we, the users, have now become beholden to the data subject. So we're doing the work at their pleasure because they can pull the plug on us at any time by withdrawing the consent. That's an extraordinary principle. So if you're in the middle of a sale or conveyancing and there's a problem, they can withdraw the consent to the user. But we shouldn't tell the buyers and sellers that, of course. But there it is. All right, so only in the case of direct marketing does the legislation specify a particular format of consent. That is Form 4. It's in the Government Gazette. But for the sake of proof, in other circumstances where consent is required, I still recommend that you have it in writing because it might be his word against your word. So basically, get written consent in all instances when you're starting to deal with a customer client. Direct marketing. Now this is section 69. Now all of this on the screen is directly transcribed from the legislation. And so it is a prohibition in certain instances. And it says here, direct marketing by SMS, email, or automated calling machines, it says, is prohibited. Direct marketing by SMS, email, or automated phoning is prohibited, unless the data subject has given consent to the processing or is a customer of the responsible party. You may approach a potential client only once in order to request the consent of that person. The signed consent must be obtained in terms of Form 4, which I'll deal with on the next slide. The legislation goes on to show or say that a responsible party may only process personal information of a data subject who is a customer of the responsible party if that responsible party, that's the agent, the conveyancer, has obtained the contact details of the client in the context of a service or the sale of a product. If the data subject has been given a reasonable opportunity to object to the messaging, and it also says that any communication must obtain the identity of the responsible party, that's the agent conveyancer, the address of that party to which the recipient may request all of his information processing to be stopped. Here is Form 4, comes from the Government Gazette in 2018. As you can see, it's an application for the consent of the customer for the processing of his information, and it says for the purpose of direct marketing. It has a place for the identity of the data subject, the customer, and we put in where does it come from. That's from Denoon, Sampson and Lawber attorneys. You have to insert your contact details. And then part B is the names of the data subject, and then it says, your customer hereby gives consent to receive direct marketing of goods or services to be marketed by electronic communication. Then it enables your customer, your client, to your potential client to indicate whether by SMS, email, and I presume WhatsApp, I would add that in, is a place for the person to sign. You have to have that if you're going to do direct marketing. Now, I see that most agencies seem to have these digital online lead management systems, and it seems as though cold calling and approaching a client is becoming less prevalent, because if you have online marketing websites, Facebook, you draw inquiries from clients, and therefore you'll still need a consent, but not in this particular format, but you might as well just use it anyway. The general consent to the process of personal information. If you're not doing direct marketing, you still need a general consent, section 18, I think. And it would read like this, and this is an opportunity to get a selling mandate, because now you have to start off with consent. So you might say something like this: I, the undersigned, this is the potential seller, give my consent to the processing of my personal information, including the disclosure of my home loan account number and bank details, to Donald Duck Real Estate, of which its address and contact details are there. You have to put in your contact details and address. And then you have to specify the purpose of carrying out the following work. It might be assisting with the sale of my property, assisting with the purchase of property, and you could also add in by providing my information, enabling the staff of bond originators, banks, coordinators, and all of those involved to process, send and transfer and register my information, which would include cancelling of bonds. You'd also need this if you're going to do valuations and the rental of properties. So there's a general consent. You might want to embed that in the mandate. Now, we're going to be talking about lead generation, and we're going to be focusing now on existing clients. You may market services to existing clients, but which services are similar to those that were provided originally when you acquired such information. Don't forget, you have to give them an opportunity to opt out and to cease the marketing should they ever want to, and it's at any time. Lead generation. Here is section 18 again. Unless the information, so let's start off again. You are allowed to capture information from public bodies, capture inquiries from the internet and social media. It says there, section 18, unless the information has been deliberately made public or appears in a public record, such as in the deeds office, for instance, the personal information that you collect requires the following. Again, the client must be aware of the source that is collected, the name and address of whoever's receiving it, that's the law firm, the state agency, and the purpose for which it's being collected, and whether or not the supply of information is voluntary or mandatory. We've done this before. And just to summarize, if you are harvesting information and you are doing it electronically by automated electronic communications, you have to go back to that section 69 and use form 4. And all of this has to be done before you collect the information. But interestingly, at the end there, section 18.2b, it says in any other case, as soon as reasonably practical, you can get consent after it has been collected. I'm sure people are going to use that a lot. Purchasing leads. You can purchase leads from a seller. That's a debt recording company, I think I'm not quite sure where these leads come from, but if you're purchasing a lead from a seller, that person has to previously have the consent of the user. So you can only buy that information if there is consent. And if I was going to be buying information, I'd want to make sure that the seller of that information to you has previously got that consent. Because if there is no consent, you cannot buy the information. So you could start again, and you probably would have to start again by getting consent again or for the first time. Cold calling. This is more or less the same as automated harvesting of information in terms of section 69. You may only once approach a prospect in order to request his consent. You should probably use form 4. And if in the context of a sale or service, an agent is doing it, he may process the information if the data subject has been given a reasonable opportunity to object. As we said, any direct marketing must contain the identity of the sender and his address, enabling that person to request all communications to stop. As I've said again, the above consent can be withdrawn at any time. Offers to purchase. I think you must include a clause in your standard form agreements. And here's an example. You might say the sellers and purchasers hereby consent to the participant estate agent, conveyancing attorneys and their staff to processing our personal information for the purpose of attending to the property transfer, collecting the finances, disclosing mortgage bond account numbers for the issue of bank guarantees, attending to the required payments inclusive of bank details, as well as liaising with bond registration attorneys and lodging in the deeds office and registering transfer of ownership. I'm sure this type of clause would be maybe elaborated upon according to each agency's unique requirements. Lease agreements, the lessor and lessee, that could be the landowner and tenant, hereby consent to the participant estate agent. Processing our personal information for all purposes concerning this lease agreement in accordance with the Act. Such consent includes the right of an agent to work with and disclose our bank details and to enable payment of deposits and monthly rentals. Records management and retention, section 14. The Act requires that personal information records are kept and maintained. The Act envisages a comprehensive filing system in terms of which the information is kept up to date. It should be only retained for the length of time that it was intended to be used. So if you have got a sale and you obtained information to have a sale and then you completed the sale and you handed it over to the attorney, is the purpose of having that information now extinguished, or would you wait until registration of transfer? Maybe you would. So your use of that information and the purpose of having it has now come and the time has passed. So then the law requires you to destroy that information, actually. But now this legislation could be overridden by other information. So we've just received from the Law Society an instruction that we have to retain all our records for 7 years, long after the transfer was registered. And your records have to disclose the purpose for which that information was gathered. I see some of these lead collecting databases have the first question in their questionnaire when a person registers with them as to whether or not your purchase will be a cash purchase, or whether you will have a bond, or whether you first have to sell your own property. So the legislation requires sophisticated records management and retention. Keeping track of your leads, and this leads on to this. So you need a digital information management system that is going to manage your leads and to keep that information that I referred to on that previous slide. The days of manually updating your diary and manually updating your spreadsheets are fast disappearing. We have a colleague who has 49,000 leads, and as much as 74% of them are completely active and up to date. Nobody can handle that sort of thing personally. And I see that we're moving into the automated messaging world where nothing is personalized and it's a computer that's managing leads. But the thing is, it's highly sophisticated and it really seems to benefit everybody. There are many great benefits of digital electronic management of leads. And some of these systems are fully compliant with the POPIA Act. They retain inbound, opted in and qualified leads. They filter out junk leads and they classify the information in accordance with purpose, and you will have zero shrinkage and you will not lose any leads. You know, if you wrote it on a scrap of piece of paper in the restaurant, I don't know how many times you've lost that type of information, but if it was on your system or on your phone, some people keep everything on their phone, which has to be secure. So this is what I've observed. As a conclusion to this presentation, the rise of criminality, fraud and theft has brought about the compelling need for institutions and ourselves to protect the information of our clients. We must ourselves have peace of mind, and we need also to give peace of mind. We have to be protective in the way we manage and use other people's information. The very essence of POPIA and this legislation, it boils down to two main principles, is that you have to have permission to use other people's information. And as an authorized custodian, you have to keep it protected. So you have to have consent and you have to protect it. That is the essence of this legislation. But it's huge, but it boils down to two principles: consent and protection. One benefit is that the new legislation now provides the impetus on us to modernize and to streamline the way we handle information. The result is that our selling techniques will become much more efficient, sophisticated, and we will improve our sales rate. Ladies and gentlemen, that's the end of the function or the seminar, and I hope it has been useful to you. Remember that graphic where you've got to keep all that information in your head, transfer it from your laptop into your head. It's about awareness, having consent, and keeping it protected. Thank you very much, everybody.